Welcome to Shaping Your Success, brought to you by the Law Society of Scotland and Hay Legal. Today, I am joined by Professor David Cabrelli. David is a professor of labour law at the School of Law of the University of Edinburgh, also serving as the Deputy Head of School and College Promotions Representative. David has practiced commercial and corporate law for 6 years before starting his lecturing career at the University of Dundee and then the University of Edinburgh, where he has been teaching and researching since 2007. His focus is on labor, employment law, company and commercial law, as well as private law, having published extensively in these areas. Now, I would like, first of all, to thank you so much, David, for joining us today. And I would just like to kick off by asking you, how did you decide to go into law in the first place?
Well, I was particularly interested in the social, economic, political, also demographic processes at work and how they shape the rules and principles by which we attempt in societies to control behaviour or guide behaviour. So that's really what interested me. I also at school was very interested in politics and historical sort of processes regarding the recent past and the modern period. So I always enjoyed that aspect of the humanities and social sciences. So I felt that, law would be a good fit in terms of public law, constitutional law, which I found fascinating, and also did enjoy writing at school and also engaging in debating societies. So for me, law was a natural choice. When I started my law degree, I wasn't entirely clear as to what my end point would be in terms of a career. It was really, the way I looked at it was 4 years at university. And if I did want to become a solicitor in Scotland, then I had the additional year of the diploma in legal practice, which is ultimately the direction that I took. But my main driving force was not that I wanted to become a solicitor. It was more really about the sort of, the way that the tectonic plates of social policy and economic shift and political perspective shifts and how they actually affect what the law is.
Mm-hmm. And what made you decide to pursue an academic career eventually?
Well, I did practice as a solicitor for around 6 years and I enjoyed it. There were certain aspects of being in a busy law office that I found a little bit frustrating in terms of not being able to perhaps research what the law was on certain issues, because as solicitors are fully aware, when it comes to legal practice, the most important thing is producing the documentation that your client expects you to produce, sometimes at short notice and at speed. So the luxury of, burying your head in the books or online to identify how the law is developed and how that will affect the document that you have and that you're sculpting and revising, just didn't have that luxury. So I often wondered about certain issues that I was practicing, impinged on what I was practicing and what the law would be. So when I was a solicitor, I started to write articles, mainly about Scots private law and how it affected the practice that I had, which was mainly based around commercial contracts or employment type contracts. So that was really how I got into academia, because I had this passion for researching the law and then writing about it and then seeking an outlet for the pieces that I'd written. So after a little while in practice, I'd say after maybe the third year, this is something that I started to do, and I was able to then have my work published. And I got to the point where I think it was around about, it was maybe late 20s, and I thought, well, if I want to move into academia and go down the research route, this is probably the right time to do it in terms of salary ranges at the time. So I made that. It was looking back, it was quite a brave move, I think, because you leave behind the security of your legal practice and your salary, and you then attempt to become a lecturer in academia, which is not necessarily an easy process to negotiate, but I was lucky.
Did this prove to be a driving force for you to choose this particular branch of law, meaning mostly labor and employment law?
Yeah, I think as a lawyer, what you're presented with is a large volume of law, and it's the law that is in the books, the law as it is. Behind every law that's expressed as a rule or a standard or a principle, there is like a legal policy behind that. There may also be a social or an economic policy decision behind that, or even just a political or demographic reason for the way that or even cultural. So that's really what's fascinated me about the law. And the difference between being a legal practitioner is that you don't necessarily need to engage what the underlying policy is. Rather, you just need to engage with what the law is. And that is what you are then building your practice around. And also looking at ways in which you can perhaps achieve a commercial route, which on its face seems to be prevented by the law as it is. So I think that was really more what I was interested in. It was more like, well, why is it the way that it is? Why is it not something else? Why is it, say, a third different thing that you can think of in another country? Why do the French do it this way? What's the reason behind that? Which again they're not really questions that you have the luxury of delving into in practice, because the time is recording and your client's obviously paying for it, so you just have to get on with the actual legal work that is necessary, the law that you find, rather than what you think you ought to find.
Yeah, I agree. I don't think a client would actually be very inclined to find out about a comparative analysis between Scots law, let's say, and continental law of any sorts. But that's why academia is there for. So how important do you think academia is to legal thinking, but also to legal practice?
Well, for legal thinking, it's obviously essential. If you just take one area of my subject, labor law, if you were to look at labor law 40 years ago, you would find a dearth of legislation, and you would only find what is now called discrimination law in an embryonic form. It wasn't even born. Whereas now, if you look at labor law, there's a mass of legislation. You've got common law rules, and you also have, as part of labor law, a subject in its own right, which is equality and discrimination law, which is just grown up. And the thing about academia is we get to think as to, well, why has that happened? Why is it that there is now a massive discrimination law when you compare it against its associated subject, which is employment law? And the reason for that is really cultural, massive changes in social thinking. People 40 years ago would think of themselves in terms of perhaps class structure, whereas now people think of them, how they define themselves in terms of their identity rather than their class. And that's why we see discrimination law getting bigger and bigger and bigger, because it's reflecting massive movements and tectonic plates in society as to how we think of ourselves. So that's why it's important for legal thinking. In terms of legal practice, like academia, there's a lot of writing, a lot of research on potential areas in which either an entire legal subject can go, so different directions, or even parts of particular legal subjects could go. So if you take the law of contract, there's a lot of work on the rules of interpretation of contract, also the rules of implication, so implying terms into contract. There's masses of academic work on remedies for breach of contract, such as how you define and calculate damages, to remedies such as specific implement in Scotland or performance in England. So this is a resource which legal practitioners can tap into. And also, if you're a legal practitioner, and you have an interesting case and you have to present it in court, then this is a rich source of material that you can draw heavily on to perhaps try and, have the law move off in a direction which is in, the best interests of your client, because in your view, the existing doctrine of the law is not necessarily working. So that's what's good about legal academia and, the thinking, the underlying thinking that's been carried out by academics in generally forging new directions for the law. Now, that can be through the common law system, sort of incremental movement in cases, decided cases. And also, of course, we've got the Scottish Law Commission, which does a lot of work, which is guided partially by academic thinking and academic output, which then culminates in, draft bills, which perhaps are then taken up by the Scottish government and presented to the Parliament for enactment. So that's the more sort of practical way in which legal academics serve the wider legal profession, I would say.
Mm-hmm. And that is, of course, what also, I would guess, makes academic studies, both undergrad and postgrad ones, quite vital for future legal practitioners.
Yeah, absolutely. I think in our undergraduate teaching, what we try and get across is what obviously the law is, so that students are equipped for daily practice, but also get them thinking about what the law could be and what it's about to become, because there are various research projects underway, which on the face of them, one of the criticisms of academia is, well, why are you doing these research projects? Because they don't have a hope of ever being enacted. Well, that may be the case this decade, it may be the case next decade, but perhaps in 20 or 30 years' time, such projects will actually be more realistic in terms of being picked up by policy groups and even by the Law Commission and then enacted. So that's why we ask students at undergraduate, but also at postgraduate level, to think much more deeply about the way that the law ought to develop. One of the features of our postgraduate study and programs also is that they are intensely comparative in nature. So a lot of our courses are really focusing on how other countries approach the same problems. So, we'll look at English law, we look at French, German law, we'll also look at Spanish law. And the reason for that really is because, the postgraduate cohort of students is very international. But I think more importantly, it's quite helpful for the development of our law in Scotland, because there are so many gaps in Scots law. And the problem is that we just don't have a sufficient amount of case law. So we have lots of legal issues that have been addressed by other legal systems, principally, I would say, civilian jurisdictions such as Germany, the Netherlands, and France, because they have civil codes. But we just haven't actually had the opportunity in Scotland to confront those problems and identify legal rules. So that's why we will ask students to look at the comparative material and select what is the best rule with the best fit, say, for Scots law. So that's another aspect of postgraduate teaching, which is very important and very useful for future legal practitioners, just because of the amount of the underdeveloped nature of some areas of Scots private law, principally, not so much criminal law or public law and constitutional law, but more about the private law.
And I think that relates to what we were also discussing beforehand, and that phrase that you used, that law is a web, and you have what's posited, of course, but you also have the directions where we're heading. And I think academia, as you said, is very good at pinpointing where we're heading and sort of pushing the boundaries of law.
Yeah, absolutely. Not only that, it's also quite useful to get across to our undergraduate and postgraduate students, and also just in our general writing, that, as we say, the law is connected by a web, and it has to be, insofar as you can, a coherent whole, so that family law interconnects logically, say, with succession law, which interconnects logically, say, with property law, which interconnects logically with the personal bankruptcy laws, which interconnects logically with corporate bankruptcy law, which interconnects logically and coherently with company law, and so forth. So it's really this idea that you can't really have an area of law that sits in juxtaposition to another area of law, and both of them are doctrinally or conceptually incoherent, because although legal practice is really important, it is underpinned by a theoretical foundation. So there's nothing worse than a bad law, and a bad law generally is a law that's incoherent or impractical. And I think it's our job to point out when laws or decisions, say, of the court or legislation that's recently introduced, or it was it may even been on the statute books for 40 years. It's our job to point out when the law needs to be reformed and what direction it ought to take, and how it can or ought to be changed. I think that's extremely important.